I think that there are three factors that the new director should put front and center.
When David Boundy was the vice president of intellectual property for Cantor Fitzgerald, he famously helped lead the successful effort to stop the USPTO's 2008 rules that would have severely limited the ability of innovators to pursue patent rights. Since then, he has become known as a leading authority on the intersection of administrative law and the USPTO and his continued efforts to improve America's patent system. So, what does he think the new director of the USPTO should focus on?
The first is quality. The second thing is efficiency. And the third goal for a new director is rulemaking.
While at Cantor Fitzgerald, David worked with longtime CEO Howard Lutnick. Howard is a strong proponent of patents who has even credited patents for saving Cantor after 9/11. He's now leading Trump's transition team and is Trump's pick to be Commerce Secretary. As a reminder, the USPTO happens to be an agency in the Department of Commerce. Therefore, Lutnick will undoubtedly play an outsized role in picking the next USPTO director and how the USPTO operates during the next administration. Welcome to Clause 8, presented by TradeSpace, a revolutionary end-to-end AI-powered IP management platform that helps companies unlock the value of their IP. If you enjoy this show, please take a minute to subscribe on clause8podcast.com. Today, David Boundy is joining Clause 8 for a jam-packed episode, including what it was like to work for Howard Lutnick.
Howard is extremely result-oriented, and Howard is absolutely focused on good results.
Plus, he discusses what Howard might be looking for in a new PTO director. And now, here's your host, Eli Mauser.
David, thank you so much for joining Clause 8.
Oh, my pleasure.
First of all, I got to share a few things. You've been on my list of guests for a long time, and listeners of this podcast probably have heard me refer to this chief IP counsel who wrote an article that said that the most valuable thing that tech companies have is engineers' time. And that article, I believe, was written by David Boundy when he was head of IP at Cantor Fitzgerald. It's something that resonated to me in my career. And recently, obviously, Howard Lutnick has been in the news, the old CEO of Cantor Fitzgerald.
And I have to correct a misimpression there. I was not the formal head. I was just the person with the most gray hair.
I see. So I was actually talking to somebody with much more impressive credentials than myself in the patent field, and he was saying he was with a former group of Federal Circuit clerks, and they were hanging out, and they were saying if Trump really wants to shake up the USPTO, they should put David Boundy in charge. And then that's the word on the street.
There might be a middle ground there. I don't want to shake up the PTO. I just want to take the things that don't work around the edges and bring them home to work the way they ought to. I'm not a big believer in shaking up. I am a big believer as an engineer in fixing things.
So we'll definitely talk about all that. But before we get to that, I want to ask you, do you remember when you first learned about patents? What was your impression at the time?
My dad was an engineer, so I was probably 8 or 10 years old, and he came home one day with something that he was working on and said, "Oh, this is just very interesting stuff I'm working on, patents." So,
And what kind of engineer was he?
mechanical. He designed electrified office panels.
So did you have a sense of the role of patents at the time, or just something engineers, I guess?
Not until I was in my late 30s, I think.
Oh, wow. So what in your late 30s drew you to patents and that helped you understand their role?
Well, I had been an engineer at Apollo Computer and Hewlett Packard, and I was just starting to see what patents did, but not really understanding the economics and business value. But it just seemed like a kind of an interesting thing. And then in the late 80s, all of a sudden, the engineer who had been chairman of Hewlett Packard retired, and Hewlett Packard was being run by finance and marketing people. And I could see that was happening all across the computer industry, was that the engineers were getting squeezed out, and it was the finance and marketing people. And I thought, this isn't going to be any fun. So I decided I'd better change my career. What can I do? Oh, I'll bet I'd be a great patent lawyer. I phoned up some people at Fish and Richardson, and they took a chance and mentored me wonderfully. I am so grateful for the mentoring I got at Fish. and I was off and running.
So how'd you hear about fish? Did you obtain any patents when you were an engineer, or?
No, I don't know. I lived in Boston at the time, and of course, fish was already the big fish in Boston. And somebody told me, oh, they take engineers and turn them into patent agents. And I thought, all right, I can do that.
As I mentioned in the beginning, the reason I'm aware of Cantor Fitzgerald is because when I started my career, I was working on business method patents, and Cantor Fitzgerald was known for their sizable portfolio in that space. Can you tell us that story? Joining Cantor Fitzgerald, why were they so interested in patents, and what was it like?
So Cantor Fitzgerald historically has been just a broker. They will buy or sell anything, from any security to they now have one of the large commercial real estate brokerages. For many years, they were the largest electronic trading platform for Treasury. I don't remember whether it was bonds or bond futures, but they are not the broker that you pick up the phone and say, I want to buy 1,000 shares of IBM. They're an interbroker dealer. So when you, Eli, want to sell 1,000 shares of IBM, and I want to buy 1,000 shares of IBM, we each talk to our brokers, but our brokers talk to an interdealer broker who actually arranges the trade. And that's where Cantor really, for 40 years, has been one of the biggest interbroker dealers. And along the way, they just started acquiring patents, and they made a fair amount of money on those patents. And then when I came along, they were starting to very aggressively patent their electronic trading systems. But Howard Lutnick, the headhunter that placed me there, said Howard Lutnick really loves patents. And over the years, it became clear he's one of the most patent savvy CEOs in the entire United States, and certainly in among Wall Street firms.
And do you know why he loved patents?
He made money at it. What else is there? I know that after I'd been there a couple of years, he told us, look, I love what you're doing because I can see that the big guys are not coming into our markets, and we don't even have to sue them. Our patents are strong enough and plentiful enough that they know they just shouldn't mess with us. And I think that let us keep our margins up, and that's what patents should be doing in an ideal world.
So that's amazing. Because of patents, Cantor Fitzgerald was able to come up with new business models, and I guess like the bigger players in the field.
Yeah, the kind of famous story, of course, is where everybody has heard of Cantor Fitzgerald is that on September 10th, 2001, Cantor had the top floor on one of the two World Trade Center buildings.
Yeah.
And we lost 700 people. And on September 12th, there was a vacant ecological niche. And lots of people should have come crowding in because we were the big player, and all of a sudden we weren't. But Howard's book says, what did I have left to rebuild with? And the very first thing he says was, I had the patents.
Wow.
There are people that believe that the reason Cantor Fitzgerald survived 9/11, patents were a big piece of it. There was obviously that it was a lot of hard work by a lot of good people. And having built a solid business before 9/11 and having facilities in New Jersey and in London, but patents were just a big piece of keeping the business running.
That's an amazing story. And you joined, I guess, Cantor Fitzgerald in 6 years after that. It was already such an important part of the company, as you described. Do you know why you got chosen? And I guess what was your role there once you...
So maybe you remember in 2005 and 2006,
Yeah.
the Patent Office had a backlog. And the Patent Office decided that, what's the problem? Why do we have a backlog? Too goddamn many inventions, and they're too damn complicated. So in 2006, they promulgated a bunch of regulations that were about cap the number of inventions that you are allowed to invent in every 60 days. If you invent more inventions than that in 60 days, tough luck, don't patent them. If they're too complicated, tough luck, don't patent them. And if you can't convince an examiner in four rounds, tough luck, give up. You can't file further continuation. You can't file further continuations to patent more inventions that are in a family. So the patent office, the roadshow talks they gave was quite blunt. We have a backlog, and these regulations are to unclog our backlog. You inventors, you can go to hell. They didn't quite say that, but that was the attitude. I just happened to be the patent lawyer with some background in administrative law, and I knew how to fight them. And I wrote some of the briefs for Dr. Taffas, and I started a fight in the Office of Management and Budget under the Paperwork Reduction Act and Executive Order 12866. And OMB, the head of IP at Cantor, knew I was the person that could do this. And if patents are valuable to Cantor Fitzgerald, then the person that can kill these rules is valuable to Cantor. So he hired me. And so my job was to kill the rules, and they got what they paid for.
And who was head of IP at the time?
Dean Alderucci.
Okay. So you joined, and that was a successful effort to not put those, I guess the story they lost in court, and then once the new administration came in, they withdrew them. Was that kind of a...
There's a story there. The file history at OMB didn't become public until what you just said, till the court case was over. But while the case was in briefing for summary judgment, OMB told the patent office to remove these rules. You must stand down. Case was over. But somehow the general counsel at the patent office forgot to tell the parties and forgot to tell the judge. And the case went on for another 18 months over rules that were dead. And I think there's a Rule 11 sanction to be had there. It's not my job to bring it, but it was really pretty sleazy that the rules were dead and they kept fighting them anyway. There had been lots of conversations with the PTO before they went final with the rule. And the notice of final rulemaking was 100 pages of, yeah, people complained about this, go to hell. People complained about that, go to hell. We're doing it. That was the attitude at the time.
And I'm laughing because that's what the rules about the fees that were just put in place. I guess some said there's a similar attitude that they took.
The pendulum swings back and forth, but at the 2006 to 2009 period, there was absolutely an attitude among John Dudas and John Dahl and Jim Tupin, the general counsel, that applicants are the problem. They can go to hell, and we're going to help them go there.
So I want to get back. Obviously, they didn't succeed with these rules, but another thing that was happening at the time was this rise of this narrative about patent trolls, and they were citing all these quote-unquote ridiculous patents that were being issued by the USPTO, and other things succeeded, including restricting eligibility rights, obviously the eBay decision, getting rid of injunctions, and then obviously the AIA. What was the climate at the time? Why do you think it got to this point where all of these anti-realities happen?
The thing I have learned in all of my conversations in DC is that almost everybody, at least in Congress, at least at the time, things have changed in 10 years, but at least at the time, almost everybody was there for the right reason, was trying to do the right thing for the right reasons. But everybody is a captive of the information receive. The simple fact of the matter is that patent trolls exist, and they're nasty people, and I've defended a couple cases, and I even represented one once upon a time.
Well, your client is never a patent troll, right?
Yes. My client was, in one case, a patent troll. There's just no two ways about it.
Yeah.
And they had a somewhat better story than most, but there's no question that sometimes there are patent owners that are bad actors, and there are patent infringers that are bad actors. And the simple fact of the matter is they both exist. But the more important thing is that the patent defendants are the folks that have the dollars to pay for the lobbyists. And everybody's trying to do the right thing, but whose information gets distributed in Washington, D.C.? The people with the money to pay lobbyists to paper the walls are the ones whose stories get heard. And that's just the way it is.
Some people say, well, let me just pick business method patents. We don't need business method patents. Who knows if we need software patents? Everything would be fine and the same if we got rid of this. Maybe we need some pharmaceutical patents. What is your response to that?
Who's telling the story? Remember what network externalities are? It's where the value of something arises because everybody else has the same thing. So the reason Windows is valuable is because everybody else has Windows, and the data files I create on my Windows computer are interchangeable with the software that runs on all other Windows computers. And it's even more so with the Microsoft Office suite, right? If I create a spreadsheet or a doc on this computer, it should be readable on every other computer. Well, it isn't, but that's what makes it valuable. Is the reason that WordPerfect is gone is because you can't read a WordPerfect document on another computer. And Cisco basically owns the standard on IP routing. Microsoft basically owns the standard for operating systems and office productivity software. Intel basically owns the standard for the interface between chips and software. Because each one of them has this network externality protecting their market, they don't need no stinking patents. And pharma companies do. But who's doing the innovation in the software space? It's the pesky people who don't work for Microsoft, Intel, Google, and the like, and who come up with new ideas that the big guys would like to use and without paying for it. Patents work basically the same way in the software space that they do anywhere else. It's just that you have this important other market barrier of the network externalities and the cost of market entry. What would it cost to rebuild an absolutely compatible equivalent to Windows or to the Office suite? It couldn't be done.
Yeah, so it's really about the big incumbents have an incentive for others not to do what I guess Cantor Fitzgerald did after September 11th in terms of being able to protect their innovations.
Innovations protected by patents are a pain in the neck for the big tech guys. They always keep ending up on the wrong side of the V. And there are some people that are bad actors and some that are virtuous. And for the big tech companies, it's just an easier story to tell that they're all bad actors. So squish them all.
Yeah, and I've always actually found that interesting. There are industries where it's a kind of built into respect IP rights, did what was doing, that if somebody has a patent, we should design around it or approach it for a license or do something else. Or if they approach us and say, we have a patent, then the same.
Yeah. And just in the Massachusetts legislature, we had a bill to penalize patent trolls, and it was kind of an overreaching bill. And working with the Boston Patent Law Association, we came up with a nuanced bill that tries to draw the line between bad actor patent trolls and the virtuous universities and innovators. And I think we did a fairly good job. And that bill hasn't been enacted. It's very difficult to draw a line between the bad actors and the virtuous patent owners. But it can be done, and I think that's one of the things that Congress is captive of the people who give them information. And that's one piece of information that I think would be helpful is that Boston Patent Law Association bill.
Actually, that's interesting because there's an argument that, patent is an asset. Who cares who owns it? Who cares? There's frivolous lawsuits in all kinds of areas. Mm-hmm. You can't stop that at all. What is the line that you would draw, or maybe the bill?
It's been 3 or 4 years since I looked at it carefully, but it does. Look, a good asset can be used for a bad purpose, and a bad asset probably can't be used for a good purpose. But the information cost of separating valid patents from invalid ones is very high. So it's a difficult problem to solve, but it can be solved.
What impact do you think all of that has had?
I think the America Invents Act, I think it was a combination of good ideas that the courts had already implemented and bad ideas. And I think people are starting to see, I published a couple papers around then that there were several bad ideas in the AIA, and indeed now we see that they were bad ideas. They really are quashing innovation and creating more cost and just making dispute resolution more expensive. And at the time I was telling people, why is the AIPLA supporting this bill? When patents become less valuable, patent lawyers will become less valuable. And indeed, we're one of the very few areas of law practice where billing rates have been basically flat for over 10 years because the AIA devalues patents. And well, it's not just the AIA, it's also Alice and eBay, but when patents are less valuable, patent lawyers are less valuable. And I think the AIPLA dropped the ball on us.
So I think probably the biggest thing that the AI created was the PTAB, right? And I'm guessing that's what you're referring to in terms of...
And also, I think the loss of the grace period. There are a lot of inventions that take more than a year to really vet out and perfect. And replacing the grace period with provisionals, which are quite costly to file and that only give you a year, I think that was a real mistake.
And I guess where it sits now, if there's a startup, let's say in the fintech space or something like that, what is your view? Is it worthwhile to pursue patents? What's your general thinking about these days?
Yeah. Yes, subject to the same tests that you would apply anywhere. If the invention is inherently invisible so that you could never detect infringement, then a patent isn't all that valuable. If the only way to draft claims is so that end users are the infringers, and it's very difficult to write claims that will be practiced by the manufacturer or importer, that patent isn't so valuable. It's just the normal tests that you would apply to any other patent. They apply to financial services as well.
But I guess your sense is applying those tests, there is value in patents, even though with the system the way it is.
I am aware of one company that has a patent that's just a real uphill struggle under Alice. But the fact that they have a patent application pending, they tell me, is keeping competitors out of their space.
No, that's good to hear. And I guess there's also the future, right?
Yep,
But we start talking about those rules that were put in place in 2008. Then Kapus came in. I guess he got rid of the backlog, but he also was in charge of implementing the AIA. And then the next director said it's above her pay grade to deal with some of those issues. And then I guess Director Yanku came in and he tried to deal, with a kind of the Section 101 mess, the patent eligibility issue created by 101. And then he also tried to deal with the PTAB validating almost every patent they get. I think you filed an amicus brief, I believe, addressing...
It's a brilliant brief, by the way.
Yeah.
I've had a couple of administrative law professors email me and say, it's a good brief. So hopefully
Yeah. So I guess that's actually, I saw something interesting. I'm blanking on the name, but the guy who was the temporary director before Yanku, he filed the brief and he said, Kathy Vidal, it's not too late to withdraw the fintech factors. So it's heating up.
Oh,
Can you tell us your view about it? Because I think you have actually a balanced perspective on that.
Yeah. My view of FinTiv is, look, the administrative law encourages agencies when there's a discretionary range in which the agency can act to issue, they're called general statements of policy in the Administrative Procedure Act. And it's like when you go to the garage and the mechanic gives you an estimate. This is my best guess. I haven't started taking anything apart yet. It isn't a promise of a price, but this is my best guess. A general statement of policy is like this. These are the things we're going to think about. These are the things that are important to us. These are the general results we're trying to achieve. The FinTiv decision is written that way as a general statement of policy, but it's issued without notice and comment. Agencies are allowed to do lots of things that are called rules and that give you predictive value about how the agency is going to act without notice and comment, but they can't be enforced as if they were regulations. So my brief says FinTIV is okay for two reasons. First of all, the Patent Office can do the same acts as a matter of their adjudicatory authority, even if they haven't exercised their rule-making authority. There's a lovely Supreme Court case from the 60s that's on exactly those facts. And the second point I made was FinTIV is fine as a general statement of policy, but the PTAB has erred several times in treating FinTIV as if it were a black letter, hard-edged, enforceable rule. That's the error they made. They have to treat it like a mechanic treats an estimate before starting to disassemble anything. It's just general principles. And Apple, Google, Microsoft, when you challenge a patent and FinTIV is against you, you're allowed to make contrary arguments. And we have to entertain them because we cannot treat FinTIV as a binding rule. So that's what my brief says.
I mean, the positive impact that I guess it did have was less proceedings were instituted, at least when Yanko was there. Long term, what do you think should be done with the PTAB? If you had a magic wand, what is the
there's a role for something like the PTAB, and I don't quite know, and I haven't thought about it deeply enough. My biggest gripe is that the Administrative Procedure Act and the Paperwork Reduction Act and the Regulatory Flexibility Act govern federal agency rulemaking, and the Patent Office in general doesn't follow them and is very aggressive about regulating in self-interest, not in the public interest. And the PTAB is particularly bad about that. A problem is that the cost-benefit balancing and the public interest balancing that the PTAB is supposed to follow, they don't. And it's possible that if they simply followed the law and did the public interest balancing that the law requires, they might find the right middle ground. There's another problem, and that is that all other administrative law judges in the entire government have, by statute, and I guess by regulation as well, certain protections of judicial independence. When Congress created the PTAB, they carved out those judicial independence things. For instance, no other judge in the country gets a bonus for productivity. No other judge in the country gets paid by one side, their entire salary paid by one side in the disputes they hear. And then their retention in their position depends on, are they making the people that pay their salaries happy or not? How do you think that's going to work out? I don't know what Congress was thinking. Of course they decide in favor of petitioners because the petitioners pay their salaries. That can't be right. So it's a couple of, I know what's going on. You asked a question and I took it to be what's the right end point for the PTAB?
Yeah, that's what I was.
Yeah, and I don't have an opinion on that. What I do know is that some of the intermediate implementation steps don't follow the law that applies to the rest of the government. And part of the things that people complain about the PTAB are precisely because the PTAB doesn't follow the law that applies to the rest of the government. Partly because Congress carved them out by some, partly because the PTAB just decides we're not going to do it.
The other big issue that I guess I mentioned is Section 101, patent eligibility. And the solution for that, the mess of the jurisprudence to make it kind of allow examiners to apply it, was the revised 2019 guidance. But people who deal with the USPTO on a daily basis and run into Section 101 issues see that even that is unwieldy to be applied in a consistent manner by examiners. I guess any thoughts about what to do about Section 101?
Para, I think, is very close to the right answer.
And that's a bill. In this
PERA, Patent Eligibility Restoration Act. It's a bill sponsored by Senators Coons and Tillis. I think it's up for hearing. There's no way it's going to be enacted in these waning days of the current Congress, but it might come back. And I think there are some things around the edges that I would tweak a little bit, but basically there are one or two things where I would change the burden of proof. I think the line it draws is just about right. But remember when you were in grade school and you had on the number line, you had closed dots and open dots? I would change some of the closed dots to open dots in para. But keep the same line, but just shift the burden of proof on a couple of places, on a couple of the lines it draws.
What about pure business method patents? Do you think is there a reason why those should not be eligible?
That's the thing that para, I think, corrects. Let's take the invention in Bilski as described. What does Bilski say? He says, a bunch of people get in a room, sit around a table, talk for a while. At the end, they say, that's a great idea. Let's do it. How would you prove infringement? How would you prove prior art to invalidate it? If you're the accused infringer, how would you ever find prior art that would invalidate that patent? So when you say pure business method patent, I think they should not be eligible because the legal system just can't deal with them. But I think patents on computers programmed to implement business methods should be quite broadly eligible. And para tries to draw a line between those two. And I think it draws the right line. I just think there's one or two things where I would turn the burden of proof the other way.
What do you think needs to happen, I guess, for it to get over the finish line? Because I think people have given up on the courts. So
The U.S. inventor is the problem. And simply put, when I attend their meetings and they just don't understand what the bill says. The words on the page say this. U.S. inventor says it says that. This is not that. And they've got enough members that make enough phone calls that they're the problem. And it's very unfortunate.
We talked about PTAB 101. In this administration, in the beginning, you said when you got involved with Cantor Fitzgerald, the reason you did is because there were a huge backlog. There were like these rules being put out that weren't putting innovators first. And I guess there's a similar feeling now with this frenzy of activity that we've seen over the last 3 years. All kinds of questionable rules, notices. The USPTO seems, and some people distracted, and now there's a growing backlog. Any thoughts about how do we come to this point again? And I guess what's the future?
I think that there are three factors that the new director should put front and center. The first is quality, but not quality of the patents, quality of examination, the type 1 and type 2 error. The Patent Office conducts its business much the way that Detroit built cars in the 1950s and 1960s. Detroit, they used to run the assembly lines as fast as they could reasonably get them to go, even if that meant that the people trying to assemble the cars couldn't do it well. And so you would just throw the car together and then leave it to a quality control station at the end of the assembly line to try and find and fix all the defects. And it didn't work very well. Detroit cars were just junk in the 50s and 60s and early 70s. In the early 70s, Japan, with the help of W. Edwards Deming, is the name that comes to mind here, learned that no, to make a quality product, you have to start with quality from the very first step. And you have to slow the assembly line down so that every bolt that gets attached to the car gets tightened to the right torque. And first the Japanese automakers and then the Swedes, and then finally, when they were starting to go bankrupt, Detroit said, you know what? We have to engineer quality first, not quantity. And that was what saved Detroit. Now, the Patent Office operates like the bad old Detroit. The Patent Office rewards examiners for working too fast and just sending out office actions without fully researching the prior art and without really comparing the prior art to the claims. Just get that count, send it out. And there's no meaningful quality review of examiner work product until very late in the process, either appeal or the quality review at allowance. And that means that There's just a huge amount of effort that's done by everybody based on bad quality work product. And then the patent office compounded the problem by weakening the PAPs, the performance appraisal plans for examiners, so that examiners today are just less trained and there's much less focus on quality and really understanding the law that's to be applied. So I think that one of the first tasks for a new director is to do what Edward Stemming did with car manufacturers in the 70s. Got to focus on quality examination. Rejections should be quality so that when I see an office action, it's reasoned through, and I don't sit here thinking, why is this all wrong? Why is this baloney? How am I going to attack it? A rejection should mean I thought about it and I rejected this for a good reason. It shouldn't be an invitation for the attorney to look at the office action and find all the points of silliness in it and fight it.
No, that's an interesting point you bring up about when quality review happens, because there are examiners who don't want to allow applications because they're afraid of getting quote unquote errors. And the way to avoid that is to keep rejecting until they're encouraged to allow the case.
Yeah, I don't know what the subjective intent is, and I certainly don't want to extrapolate. I assume that you're correct and that there are some number. I don't want to extrapolate that that's large, but it is unquestionable that the processes are designed to delay consideration of quality, particularly of rejections. I had 3 points. That was number one. Would you like number two and number three?
Yeah, because your other points, I guess, related to what I was going to say.
So I think the second thing is efficiency. The problem is that whenever you read a rulemaking notice or anything like that, the Patent Office's idea of definition of efficiency is efficiency of the examination process. There's no consideration given to efficiency for the applicant. By law, under the Paperwork Reduction Act and several other laws, Patent Office is required to look at total net efficiency of the system, and they just don't do it. The definition of efficiency at the Patent Office is narcissistic, and I think that's a problem. And the third goal for a new director is rulemaking. The Administrative Procedure Act and the Paperwork Reduction Act and President Trump in his first term, a couple of executive orders require agencies to regulate genuinely in the public interest, to gather the information that's necessary to reach good decisions, to reach genuinely public benefit rulemaking. And the Patent Office just shortcuts the dickens out of that rulemaking. For instance, most of their recent rulemaking notices say, well, we've already requested and received approval under the Paperwork Reduction Act under such and such control numbers. And then you go to the file for those control numbers and the Patent Office never applied. It's just a flat out lie in these rulemaking notices when the Patent Office claims to already have approvals. And you can't make progress when you start with just plain false statements by the Patent Office's lawyers to their regulators. And I hope that the new director will take the law of rulemaking seriously. So those are my 3 points: quality, efficiency, and rulemaking procedure.
All right, so I want to ask you a couple of questions about that. One, I guess your first question, somebody might say, well, there's 10,000 examiners. If you don't put these accounts in place, it's too hard to do what you're saying, check quality everywhere. You got to put these counts in place, and then they got to do their thing, and it works. Okay, what's your kind of thoughts?
It would be simple to improve quality. What does the current count system incentivize? It incentivizes more office actions, right? In any other business, we'd say measuring the quantity of inputs that you consume and the costs you create is the wrong metric for performance. You should measure the outcomes. So I think one thing you could do that would be a huge thing would be to have the count system. You get your counts when you have a final disposition, either a final abandonment or an allowance, you don't get counts for consuming resources, or at least your total count metric is not based on how inefficiently you consume resources.
Correct me if I'm wrong, but what I'm hearing from all these proposals is the USPTO should be thinking more about the innovators and the applicants.
Yes, it is. The problem, as I see it, is that PTO management tries to optimize too small a machine. It's like optimizing machine for the machine to service itself, not for the machine to do the job you bought the machine to do.
What kind of person do you think would be suited to do these type of things?
I thought David Kapos was very good. It should be somebody who's trained first as an engineer and also as a practicing lawyer. That problem-solving skill that you get as a practicing engineer, recognition that you have to optimize for and reduce costs over the entire system, not over part of the system. I think that's really important.
Obviously, you probably know Howard Lutnick much better than other patent attorneys out there. There are patent attorneys listening to this who might be interested in how they might attract his attention, or they'll be interviewing for a position, how they might present themselves as the best candidate for the USPTO. Any advice for them?
Howard is extremely result-oriented. It's Wall Street. At the end of every day, you have a number, you either made money or you lost money. And Howard is absolutely focused on good results. He's quite willing to break things. I think he will have a very good understanding of the economic consequences of what the Department of Commerce does.
I want to just end with you because obviously there's this patent world out there. There's patent attorneys who just take on clients, and as long as they pay them, everything is fine. And they try not to get too in the weeds about what's happening with policy and what's impacting stuff, and don't want to upset any of your clients or anything like that. But you're obviously passionate. You've been in the arena. I know you try to help others. You try to help others understand what's going on with patent policy. You try to impact it in a positive way. Why do you do these things, and what makes you passionate about it?
I wish I knew. My sister is the same way, and some of it is my parents were passionate about doing right. My mother particularly was passionate about doing right. My grandfather and his brother were naval officers during World War II and really sacrificed a lot to make the United States successful and a better place. Then after the war, my grandfather went back to being a high school principal in Seattle. He was a bird captain, a flag officer. And then after the war, he went back to being just a high school principal. But my mother, man, you put wrong in front of her and she would just go bananas and try to fix it. I'm afraid that for better or for worse, I learned that from her. It's a passion for justice. I guess that's why I went into the law. And I believe in the patent system as one of the engines that makes the United States successful and makes our lives all better. And it's something that the intersection of economics and political theory and technology makes it just a very interesting set of inputs that go into making interesting outputs.
David, thank you so much for joining Clause 8 and sharing your story and sharing your thoughts about the patent system. I know a lot of people will benefit from that.
Oh, you're very welcome. Thanks very much.
Thank you so much for listening. Don't forget that new episodes of Clause 8 come out every 2 weeks, so be sure not to miss it by subscribing at clause8podcast.com.